I want to address this claim that President Reagan and Bush only did a deferred action as a cleanup measure for laws that were already agreed upon by Congress, and that is IRCA, of course. However, isn't it true that Congress actually considered whether the spouses and children of persons who obtain legal status through IRCA should be granted special protection under the law and explicitly chose not to do so? And that both President Reagan and Bush chose to expand this law anyway with deferred action and work authorization?
Yes, Congresswoman, and thank you for your leadership, particularly on the Power Act. Yes, absolutely. The big difference between what Presidents Reagan and Bush Sr. did versus what President Obama has done, they exercise prosecutorial discretion. They're using existing statute to provide deferred action and allow people to get work authorization. However, both under IRCA, both Congress considered and rejected the fact that children and spouses who didn't meet certain criteria would not be eligible. And then after IRCA was passed, the quote-unquote cleanup, there were a number of amendments that were introduced at different points. The Family Fairness Act that failed. One was with cloture, the cloture vote failed. And then secondly, on October 7th of 87, the late Senator Chafee introduced an amendment specifically to amend the Immigration Nationality Act to waive the continuous residence requirement under the legalization program for spouses and children of qualified legal aliens, and that also was defeated. Despite the fact that those different attempts by Congress, and this was a Republican senator, to address this issue, Presidents Reagan and Bush Sr. decided this was unfair to deport the children and spouses of people who were legalized under IRCA. And secondly, they recognized they had the legal authority to exercise that discretion and provide voluntary departure for those individuals and eventually work authorization as well.
So both President Bush and Reagan acted in contrast to Congress, not in conjunction with Congress.
Correct. They acted against congressional will and exercised their legal authority, which was well established and continues to be well established today.
Okay, it has also been said repeatedly today that this deferred action is unfair because the beneficiaries will jump in line before millions of others who are waiting in line. Why is this incorrect, Ms. Hincapié?
So unfortunately, again, this is incorrect because there's a lot of misinformation about what the Deferred Action Program is. People are not getting onto any path to citizenship. They are not becoming lawful permanent residents. They are simply getting a temporary reprieve from deportation and will be able to work because the regulations allow them to get work authorization if they get deferred action. So we still have a need, and as Congressman Johnson was just saying a few minutes ago, there's a need for comprehensive immigration reform to address the needs of the individuals who are waiting in line. Nothing that the President has done changes in any way that need for immigration reform. And my understanding is H.R. 15 is still pending in Congress. There are still a few weeks left in this session, and I have been very comforted by the number of comments many people made today about the support for comprehensive immigration reform, and I would urge every single one of you to use the remaining days in this session to pass H.R. 15.
So, Ms. Hincapié, it's been also said repeatedly today that this deferred action creates a class of individuals who are considered for deferral of deportation, that this is a blanket non-enforcement program. Is this a blanket non-enforcement program? And for instance, with DACA, have there been denials of the applications? Can you tell me how many of them there have been? Because I've read that it's 1,377 requests that have been denied.
Right. So yes, this is not a blanket amnesty or a blanket program whatsoever. DACA, the program that's been in existence for the last 2 years, as well as the new program, is based on individual adjudications. And so again, individuals have to put forth the evidence that they meet all of the criteria. And I must say to you, Representative Chu, I mean, we have held large clinics for DACA where young immigrants have come with reams, volumes and volumes of evidence documenting all of their continuing residence, everything from from report cards to immunization records, the student of the month record, the certificates, letters, et cetera, from the school, they have come forward with a lot of evidence, and that is why it has been a successful program, because the majority of them have been able to meet the criteria required. That said, there are many who have also been denied, and in fact, most recently with the DACA renewal program, we've seen an increase in rejections of DACA applications, which we continually raise to the administration to understand the reasons for those rejections.
Would the gentlelady yield?
Yes.
I'd like,
Gentlewoman's time has expired.
I wanted to make a